We'd had a dispute going on with one of our suppliers for quite a lot of money, and I was advised at the outset, that on the face of it, we had a very strong case. One of the things we had to do as part of the legal process was to turn over to our lawyers and the other side's lawyers, the supplier's lawyers, all our internal documents that we had created, including all the emails that we'd sent to each other. We had people writing about perceived weaknesses in our case. We had people blaming people from other departments for what had happened. To cap it all, and I think this was the real killer, there was an email from the head of our purchasing department which he'd sent to a friend of his, now working for one of our competitors, in which he basically bad-mouthed the supplier. The legal advice was that all this stuff was going to create a very negative impression in the judge's mind, and the email from the purchasing head in particular was almost certainly libelous. So we were advised to settle.
I'm sorry.
Which we did, for just under 300,000 on a claim which the week before I believed was worth 6 million. I used the phrase, and I think this was spot on, that our documents, and particularly those bloody emails, were the other side's star witness, and we were caught completely unaware.
Email is everywhere. In all countries, across all cultures and all time zones. By night and by day, in offices and factories, at home and at work. Email has us all hooked on communication. And that carries risks for companies that are all too easy to overlook.
Well, the thing about email is it's a very spontaneous form of communication. It's quite different from writing letters. It's chatty, it's informal, it's immediate. You send it, it's arrived. You've hardly even thought about it. And that's fine if you're batting ideas around, if you're trying to be creative. But if what you're doing is using it as a means to discuss an impending problem with, say, a customer or a supplier, then you have to be really quite careful.
Why should companies be wary of such a powerful communications tool? What can possibly be wrong with online 24/7 communication? The answer lies in the legal procedure which stopped George Trante's claim in its tracks, and the lawyers call it disclosure, or in some countries, discovery.
Disclosure or discovery is the process in common law jurisdictions whereby parties are required to produce in litigation any document which is relevant to the case, and that includes documents which are both helpful to your case and harmful to your case.
In other words, the communication you send today could end up being read out in court tomorrow. And in the case of email transcripts, according to Julian Copeman, the arrival of the other side's documents is greeted in every lawyer's office with great anticipation. They are looking for the holy grail in any legal case.
Over the last 5, 6, 7 years, emails have become the source increasingly of the smoking gun in any piece of litigation. The smoking gun is what we're all looking for in litigation. It's the document that disproves the other side's case. Their case is one thing, you find a document amongst their papers which says something entirely different and disproves their entire case.
Probably the most celebrated instance of smoking gun emails in recent years came in the high-octane world of banking, when New York District Attorney Eliot Spitzer was attempting to prove that the big Wall Street banks were publishing overly rosy financial assessments of companies about which, privately, they held very negative views, in order to win lucrative multi-million-dollar deals with those companies, advising them on mergers and acquisitions. To make his case stick, Spitzer had to prove that the analysts in the banks who had written the assessments had known at the time that the assessments were false, and that the investors reading the reports would be likely to be misled by them. Initially, the banks denied the charges, but then came disclosure or discovery. LFMN at $4. I can't believe what a POS, piece of shit, that thing is. Shame on me / us for giving them any benefit of doubt. ATHM is such a piece of crap. I don't want to be a whore for f***ing management. If 2-2 means we're putting half of the bank's retail into this stock, then I don't think that's the right thing to do. John and Mary Smith are losing their retirement because we don't want the client to be mad at us.
Thank you all for being here.
Spitzer had found his smoking gun.
It is hard to overstate the magnitude of the betrayal.
And the bank settled, agreeing to hundreds of millions of dollars in fines. In a legal case, the state of mind a person was in at the time when they wrote the communication in question will sometimes be relevant to the issue in dispute. That can tell us a lot how individuals and corporations respond in those moments of panic which occur all too often when a problem has been discovered.
In a situation where something's gone wrong, human nature would generally dictate that people want to find a responsible person, and that responsible person is not them. The finger-pointing culture, which is sort of inherent in human nature, emerges. And people whose opinion may be relevant, but actually wouldn't have been formally recorded, is now disseminated to a very wide audience and becomes a permanent record. So actually, it is, while the underlying facts should remain of crucial importance, what becomes of almost equal importance is how the company responded to it when the event was realised or discovered.
Within this same environment of backside protection and blame assignation, another destructive force often at work is the managerial urge to investigate and record their findings to satisfy their bosses.
Yes, of course, Robert. Yes, I'll get to the bottom of this.
With damning effects.
Generally, it will be a wrong assessment, taken at the wrong time, on the wrong information, reaching the wrong conclusion, but stated with great emphasis and great conviction. Those documents are difficult to deal with. Great thought tends to be given as to who the recipient should be, and even greater thought is given to making it as lengthy a list as possible. No thought is given to the consequences of so doing. It is always disadvantageous.
The drug's susceptibilities could not have been properly tested by the research team, otherwise these failures would not be coming to light now.
My take on all this is that the officer concerned could not have had due regard to Rule 17, which obliges all officers to exercise great care when restraining...
One question the regulator is bound to ask is why this information was available at all in this part of the bank. We may ask the same question ourselves.
Once a company becomes embroiled in a dispute, when litigation or regulatory action becomes a real possibility, a further risk arises. This is that managers may take matters into their own hands and attempt to delete or destroy incriminating emails and other documents. This is exactly what happened at Auditors Arthur Andersen when, in the wake of the scandal engulfing its client Enron, frantic attempts were made to shred documents which might incriminate the firm, with devastating results.
If a problem has arisen and there's any possibility of litigation in prospect, then you absolutely must not destroy documents. And that means, you can't start trying to wipe tapes, you can't start trying to get rid of emails, you can't throw away documents and just shred documents and so on. And again, if you are trying to do that with emails, you will be found out.